Prospectus meaning. As per the definition given in section 270 of the Act, prospectus means any document described or issued as a prospectus and includes a red herring prospectus referred to in section 32 or shelf prospectus referred to in section 31 or any notice, circular, advertisement or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate. The definition of prospectus has two limbs: means part and includes part. With the four elements in total, these four constitute can be appreciated through diagram presented below. Prospectus means any document described or issued as a prospectus, includes shelf prospectus, red herring prospectus, any notice, circular, advertisement or other documents inviting offers from the public. Out of the four constitutes of prospectus definition, first three are quite clear, but the fourth one, that is document inviting offer from the public considered as deemed prospectus or prospectus by implication, needs to be decoded further, that too in the context to section 25 and landmark judicial pronouncement elaborated later. Other elements are also explained, elaborated at relevant place in this chapter. Deemed prospectus, section 25. The documents containing offers of securities for sale. Deemed prospectus, subsection 1 provides where a company allots or agrees to allot any of its security with a view that those securities being offered for sale to the public, any document by which the offer is made shall deemed to be a prospectus for all purpose. All the enactments and rules of the law containing provisions pertaining to the prospectus matters to be stated. Liabilities for misstatement shall also apply to such deemed prospectus subject to section 25(3) and 25(4). The purpose of deemed prospectus provision is to protect gullible investors from various fraudulent practices. Presumption of use. Intent to offer securities for sales to public under subsection 1. As per subsection 2, the allotment is presumed to have been made with a view of offering them to the public, where either of the following conditions fulfilled: securities are offered to the public within 6 months of allotment, or where the full consideration has not been received by the company at the date of offer to the public. It means in case if any of the above two conditions meet, then issuing document shall deemed to be prospectus under subsection 1. Subsection 1 and 2 to section 25 are not exhaustive in nature. There may be certain other situations when issuing documents may constitute as deemed prospectus. SEBI versus Kumanankulam Paper Mills Limited, where a right issue is made to existing member with the right to renounce in favor of others. If the number of such others exceeds 50, it also becomes a deemed prospectus. Requirements in case of deemed prospectus. Matters to be stated additionally. As per subsection 3, following matters needs to be stated in the deemed prospectus, that is, the document through which offers of securities in public is made under subsection 1 in addition to those required under section 26. A statement of the net amount received or to be received as consideration for the securities to which the offer is relates. Second, the time and place at which the underlying contract for allotment may be inspected, and the person making the offer where name in the prospectus as director of the company. Signing of deemed prospectus on behalf of company. Further, as per subsection 4, it is sufficient if the document deemed prospectus, that is, through which offer of security to public is made under subsection 1 on behalf of company is signed by its two directors. Matters to be stated in prospectus 26. Contents and requirements as to prospectus. Requirements as regards to date, sign and content to be included subsection 1. Prospectus shall be dated and signed and shall state such information and set out report on financial information as may be specified by SEBI in consultation with the central government. Proviso to subsection 1 says that the SEBI regulations made by SEBI in respect of such financial information or report on financial information shall apply until the SEBI specifies the information and report on financial information under Section 26(1). A declaration shall be made affirming the compliance of the provisions of the Act, the Companies Act 2013. A statement shall also be included to effect that nothing in the prospectus is contrary to the provisions of the Companies Act 2013, Security Contract Regulation Act 1956, Security and Exchange Board of India Act 1992, and rules and regulations made under above three statutes. The provisions of Section 26 shall not apply to subsection 2 if the prospectus issued to existing members or debenture holders of the company. If the prospectus issued relating to shares or debentures which are in all respect uniform with shares or debentures previously issued and for the time being dealt in or quoted on a recognized stock exchange. Date of publication of prospectus. Explanation to subsection 3. The date indicated in the prospectus shall be deemed to be the date of its publication. Filing of signed copy with registrar. A prospectus shall not be issued unless a signed copy of such prospectus has been delivered to the registrar for filing. Such copy shall be signed by every person who is named as either director or proposed director in such prospectus. Duly authorized attorney can sign in respective representative capacity. Date of filing. A copy of prospectus with registrar is important in context of concept of validity of prospectus for issue discussed under section 26(8). Condition in regard to expert statement. A prospectus issued under section 26 shall not include a statement purporting to be made by an expert if any of the following condition is met. If he is engaged or interested in the formation or promotion or management of company, if the expert has not given written consent to the issue of prospectus, or if he has withdrawn the consent before the delivery of copy of the prospectus to registrar for filing. A statement to that effect, non-existence of condition if expert statement is included, shall also be included in the prospectus. Purpose of subsection 5 is to ensure independence of expert to protect from financial interest of prospective investor who may invest in companies after relying upon the statement of such experts. Experts as per section 238 of Act include an engineer, a valuer, a chartered accountant, a company secretary, a cost accountant, and any other person who has the power or authority to issue a certificate in pursuance of law for the time being in force. Disclosure on the face of prospectus. Prospectus issued under subsection 1 shall on the face of its state specify that a copy has been delivered for filing to the ROC or registrar under subsection 4. Documents required by this section to be attached to the copy so delivered or refer to statement included in the prospectus which specify these documents. Validity of prospectus for issue. A prospectus is considered to be valid for issue only if 90 days has not been lapsed from the date on which a copy thereof is delivered to registrar under section 25(4). The date of issuing is important for many reasons, one of them being the value of securities keeps changing. If 90 days have expired after filing of prospectus, it is better to send a fresh copy of prospectus to registrar under section 26(4) to avoid the penalties imposed under section 26(9). Validity of prospectus for issue. If a prospectus is issued in contravention of the provisions of section 26, the company and every person who is knowingly a part to the issue of such prospectus shall be punished with a fine of 50,000 to 3 lakhs. Example: the board of directors of a pharmaceutical company has allotted shares to the public by issuing a prospectus that is not filed with the registrar of companies. In this regard, it is to be noted that a public company can issue securities to public only by issuing a prospectus under section 23(1)(a) of the Act. Further, section 26(4) requires that no prospectus shall be issued unless a duly signed copy of the prospectus forwarded to the registrar for filling. In the given case, the company has issued the prospectus in violation of the provisions of section 26. Hence, a company as well as the person who is knowingly a part to this will be punishable with a penalty under section 26(9) of the Act. Variation in terms of contract or object stated in prospectus. Subsection 1 of section 27. Subsection 1 provides the term of a contract referred to in the prospectus or object for which the prospectus has been issued can be varied, but only with the authority of the company giving by it in general meeting by way of special resolution. First proviso to subsection 1 requires that prescribed detail of the notice which has to be given to the shareholders are to be published in newspapers, one in English and one in vernacular language, circulating in the city where the registered office of the company is situated, indicating clearly the jurisdiction for such variation. The second proviso to the subsection 1 also prescribes that company is not to use any amount raised by it through the prospectus for buying, trading, or otherwise dealing in equity share of any other listed company. Subsection 2 provides that the dissenting shareholders, that is, those who did not agree to the variation, are to be given an exit offer by promoters or controller shareholders at such exit price and in such manner and conditions as may be specified by SEBI by making regulations for this purpose. Offers of sale of share by certain members of company. Subsection 1 of section 28. Subsection 1 provides that members of company in consultation with board of directors may offer whole or part of their holdings of shares to the public in accordance with the provisions of law for the time being in force. Further, subsection 2 provides that the document by which the offer of sale to the public is made shall be treated as prospectus issued by company. Hence, all provisions applied accordingly. At last, subsection 3 highlights the members' responsibility in matter of sale under subsection 1. It provides the members, whether individual or body corporate or both, whose shares are to be proposed to offered to the public, shall collectively to authorize the company to take all actions on behalf of for carrying out the transaction. They also have to reimburse the company for all expenses made by it on this matter. Public offer of securities to be in dematerialized form. Section 29. Section 1 has overriding effect to any other provisions of this Act. It provides that every company making a public offer and such other class or classes of companies as may be prescribed have to issue their securities only in dematerialized form by complying with the provisions of Depositories 1996 and regulations made thereunder. It. Subsection 1A inserts in 2019 provides that in case of prescribed classes of unlisted companies, the securities shall be held or transferred only in the dematerialized form by complying with the provisions of Depositories Act 1996 and regulations made under it. Further, subsection 2 provides any other company may convert its security into dematerialized form, issue its security in physical form in accordance with the provisions of this Act, issue its security in dematerialized form in accordance with the provisions of the Depositories Act 1996 and the regulations made thereunder. Rule 9 and Rule 9A inserts formed by unlisted public company inserts vivid companies. Third amendment of the Companies Rule 2014 is relevant for procedural aspects pertaining to public offers of securities to be in dematerialized form. Advertisement of prospectus. Section 30. Where an advertisement of any prospectus of a company is published in any manner, it shall be necessary to specify therein the contents of its memorandum as regards the following: objective and liability of members and the amount of share capital of the company, name of the signatories to the memorandum, number of shares subscribed for by the signatories, and the capital structures of the company. Shelf prospectus. Section 31. Meaning of shelf prospectus. Explanation to this section 31. The expression self prospectus means a prospectus in respect of which The securities or class of securities including therein are issued for subscription in one or more issue over a certain period without the issue of a further prospectus. Need of shelf prospectus. A company is required to issue a prospectus each time it accesses the capital market. It leads to unnecessary repetition for a company which makes more than one offer of security in a year to mobile funds from the public. A way out is shelf prospectus, which remains valid for a specified time period during which offers for securities may be made by a company to the public without going through the arduous exercise of issuing fresh prospectus every time. Filling of shelf prospectus with registrar. Shelf prospectus may be filled with registrar at the stage of first offer of the securities by class or classes of companies as the Securities and Exchange Board of India may provide by regulations in this behalf. It has to be indicate a period not exceeding 1 year as the period of validity of such shelf prospectus. The period of validity is to commence from the date of opening of the first offer of security under such prospectus. In respect of any second or subsequent offer of such securities issued during the period of validity of such prospectus, no further prospectus is required. Filing on information memorandum with self prospectus. A company filing a self prospectus shall be required to file an information memorandum with registrar within the prescribed time prior to the issue of second or subsequent offers of securities under the shelf prospectus containing all material fact relating to a new charge just created, changes in the financial position of the company as may be occurred between the first offer of the securities or the previous offer of the securities and the succeeding offer of the securities, and such other changes as may be prescribed. Proviso to subsection 2 provides a safeguard to applicants who made payments in advance. It is provided that where a company or any other person has received applications for the allotment of securities along with advance payments of subscription before the making of any such change, the company or other person shall intimate the changes to such applicants, and if they express a desire to withdraw their application, the company or other person shall refund all the monies received as subscription within 15 days thereof. Procedural aspects. Rule 10 of the Company's Prospectus and Allotment of Security Rule 2014. The information memorandum shall be prepared in Form PAS 2. It shall be filed with the registrar along with the fees as provided in the company's registration offices and fees rule 2014 within 1 month prior to the issue of a second or subsequent offer of securities under the shelf prospectus. Information memorandum together with shelf prospectus is deemed prospectus. When an information memorandum is filed every time an offer of security is made under subsection 2, such memorandum together with the shelf prospectus shall be deemed to be prospectus. Red herring prospectus. Meaning of red herring prospectus. The expression red herring means the prospectus which does not include complete particulars of the quantum or price of the securities. Need of red herring prospectus. Developments taking place in the financial market from time to time, allowing innovative methods of raising funds so as to avail the most of the favorable market conditions. Timing the issue and book building of issue are facilitated by the concept of red herring prospectus, whereby the price per security and number of securities are left open to be decided post closure of the issue. Time of issue. The red herring prospectus. Subsection 1. The company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of a prospectus. Filing of red herring prospectus with the registrar. Subsection 2. A company proposing to issue a red herring prospectus shall file it with the registrar at least 3 days prior to the opening of the subscription list and the offer. Obligations under red herring prospectus vis-a-vis prospectus. Subsection 3. A red herring prospectus shall carry the same obligation as are applicable to a prospectus, and any variation between the red herring prospectus and a prospectus shall be highlighted as variation in the prospectus. Filing with the registrar and SEBI upon closing of offer. Subsection 4. Upon the closing of offer of securities under this section, the prospectus stating wherein the total capital raised, whether by way of debt or share capital, and the closing price of the security, and any other details as are not included in the red herring prospectus, shall be filed with the registrar and the Securities and Exchange Board. Book building is actually a price discovery method. In this method, the company does not fix up a particular price for the share but instead gives a price range. An underwriter builds a book by accepting order from fund managers indicating the number of shares they desire and the price they are willing to pay. Concept of abridged prospectus: issue of application forms for securities. Meaning of abridged prospectus, section 2(1), section 33. Abridged prospectus means a memorandum containing such salient features of a prospectus as may be specified by Securities and Exchange Board of India by making regulations in this behalf. Need of abridged prospectus. In fact, abridged prospectus is a summarized form of actual prospectus containing the silent feature of prospectus to cut the cost involved in publication of large number of prospectus which has to accompany the application form for share or debentures in case of public offer. Abridged prospectus accompany the application form. Section 33(1) provides that every application form for shares or debentures has to be accompanied with the abridged prospectus. Proviso 2 subsection 1 provides exception when the requirement of abridged prospectus does not apply when application form is issued in connection with a bona fide invitation to a person to enter into an underwriting agreement with respect to share or debentures in relation to the share or debentures which were not offered to public or where offer is made only to existing members of the company. Right to receive prospectus, subsection 2. Subsection 2 provides that a full prospectus is to be made available to any person who requests for it before the closing of the subscription list and the offers. Penalty. Subsection 3. A company who makes any default in complying with the provisions of section 33 shall be liable to a penalty of ₹50,000 for each default. Misstatement in prospectus. A contract of share in a company is a contract of overi fide, that is Latin, which means utmost good faith. The legal doctrine of umbrime fides provides that all parties to contract must deal in good faith, making a full declaration of all material facts. The intending purchaser of shares are entitled to true and correct disclosures of all the facts in the prospectus. Hence, the prospectus must make all statements with scrupulous accuracy and not state facts which are not strictly correct. Neither any information which the law requires to be disclosed to the public be concealed or omitted to be stated from the prospectus, nor should the information given be false and misleading. Misstatement in prospectus is a serious offense which attracts the provisions of section 34 and or section 35 of the Act. In this section, we will learn about misleading prospectus, remedies for misrepresentation in the prospectus. What constitutes as a misstatement and misleading prospectus? A prospectus is said to be misleading if it includes any misstatement. The common parlance misstatement is the act of stating anything that is false or not accurate. The statement becomes false if it produces a wrong impression of actual fact. It could either be due to commission or omission or both. As per section 34, a statement included in a prospectus shall be deemed to be untrue if the statement is misleading in the form and context in which it is included or where any inclusion or omission of any matter is likely to mislead. Effect of misleading prospectus. Remedies of misinterpretation. The fear of heavy liability and criminal sanction have controlled the director's tendency of using extravagant terms and flattering descriptions. But if the prospectus contains a misleading or false statement or omits to disclose a material fact which amounts to misrepresentation, the aggrieved shareholders has the remedy. The law allows the following remedy for misrepresentation. First, right of rescission. When to seek rescission, a person who has purchased share from the company on the basis of prospectus contains untrue and misleading statement of material fact is entitled to apply the court for the rescission of contract under the relevant provisions of Indian Contract Act 1872. Effect of rescission. The agreement to take up shares is avoidable at the option of the subscriber to share. It will remain valid unless he actually resigns it. If the court accepts his application for the repudiation of the contract, company will remove his name from the registrar of company and return his money with the interest and other incidental cost. Entitlement to compensation for any damages which he sustained through the non-fulfillment of the contract arising under Section 75 of the Companies Indian Contract Act 1872. Exception: when right of rescission is not available. Right to rescind allotment of share will not be available to the subsequent purchaser of shares from the market. A subscriber to the Memorandum of Association cannot also seek any relief, as the company cannot be considered to be in existence at the time when he appended his signature to the Memorandum of Association. He cannot be said to have been influenced by any statement in the prospectus. Right of action for damages. When to evoke. In the case where misstatement amount to fraud, aggrieved investor also gets a right of action for damages against the company. This right is available even after the company has gone into liquidation. Prerequisite to claim for damages. Misrepresentation fraudulent was there in the prospectus and it is of material fact. Person is intended to act upon it. Person suffered the damages as consequences of acting upon such fraudulent misrepresentation. Civil liability for misrepresentation in prospectus. Offences under Section 35. Loss or damage to subscriber of securities as a consequence of acting on basis of inclusion or omission of any material matter in the prospectus which is misleading the subscriber, who shall be held liable, company and every person who is a director of the company at the time of the issuing of prospectus authorized himself to be named and is named in the prospectus as director of company or has agreed to become such director either immediately or after an interval of time. A promoter of the company authorized the issue of prospectus, an expert referred to the subsection 5 of section 26. Liability for an offense under section 35. A person found guilty under section 35 in addition to any punishment under section 36, a company and every other person shall be also be liable to pay compensation to every person who has sustained loss or damages. Exception to liability for guilty offense under section 35 subsection 2. Subsection 2 provides the instance when a person shall not be held guilty under subsection 35 of this act if he proves he withdraw his consent to be a director of company and prospectus issued without his consent and authority, he has given reasonable public notice to effect that prospectus was issued without his knowledge and consent, he made the statement on the authority of an expert whom he believed to be competent and that the expert had given his consent and had not withdrawn it, he had reasonable grounds for believing the statement to be true and that he did not believe it to be true up to the time of allotment. The statement was a correct copy of some extract from an official document and that he had in fact believed personal liability when he intended to defraud. Every person referred under subsection 1 shall be personally responsible without any limitation of liability for all or any of the losses or damages that may have been incurred by any person who subscribed to the securities on the basis of such prospectus. Where it is proved that a prospectus has been issued with intent to defraud the applicants for the securities of company or any other person or for any fraudulent purposes. The case of criminal liability for misstatement in prospectus, section 34. Offense under section 34. Whereas prospectus is issued, circulated or distributed that includes any statement which is untrue or misleading in the form or context in which it is included, where any inclusion or omission of any matter is likely to mislead, who shall be held liable? Every person who authorizes the issue of such prospectus. Liability for an offense under section 34. Such person found guilty under section 34 shall be liable for the punishment under section 447 of this act. Exception to liability for guilty offences under section 34 proviso to the section 34 proviso to the section 34 provides the instance when a person shall not be held guilty under section 34 of this act if he proves that such misstatement or omission was immaterial, he had reasonable grounds to believe and did up to the time of issue of the prospectus believe that the statement was true or the inclusion or omission was necessary. Note: loss from misstatement is not essential to hold a person guilty under section 34. Liability for offences under section 34 is strict liability. Hence, it is immaterial where the omission is intentional or unintentional. Both case person will be held guilty under section 34 and liable for punishment under section 447 of this act. Certain situations when a director will not incur any liability for misstatement in a prospectus are covered under exception provided by section 35(2), but no such exception specifies that relying on the statement prepared by the promoters of the company is a valid ground for a director to escape liability for misstatement.